standard long-term disability lawsuits are challenging. And we're going to talk about the reasons why they're challenging. We're going to talk about how we can win them for people. We're going to talk about what a win means in a standard disability lawsuit. But the first thing, Steve, I want to get to, which is kind of like a general thing about why are ERISA disability lawsuits against the standard challenging in general?
Yeah, so it's the law that governs them, the Employee Retirement Income Security Act, or ERISA. You know, honestly, even when I speak to someone for the first time, if their claim's been denied, I like to give them an overview of what to expect in litigation so they understand the importance of the appeal itself. You know, some of the kind of the nuts and bolts with regards to it is if standards denied your appeal, as of the date of that denial, your record closes, meaning you can't supplement with any new information. Anything that's going to be considered is locked in your claim file. It's federal jurisdiction, so you get no state law causes of action. It's only federal law. You can only sue them for unpaid benefits. There's no right to a jury trial. There's no right to live testimony, so you don't testify. Your doctors don't. No one from standard will. And as a default standard, you know, this can change depending on the policies in the area where, you know, the law. But this default is one, you have to establish that you're disabled, that basically standard made the wrong decision. And if you do establish that, then the court has to do a second one, and that is whether or not they acted arbitrary and capricious in the denial, or they had a reasonable basis to deny. So there's this idea of that standard doesn't necessarily have to show they made the right decision to deny, but based on all the information, it was a reasonable conclusion that was made to deny the case. So it puts it in a situation where, you know, standard is going to get the benefit of the doubt when looking in court. You know, and a lot of people think, hey, this is an insurance policy, it should be a breach of contract. It's not a breach of contract. You know, if these policies contain discretionary clauses, a court will also then defer to standards interpretation of their policies. So there's a lot of benefit to the insurance company, just in the possibility of win. And then even more so this idea that if you do prevail, your only guaranteed right is the benefits they haven't paid you, and then you're put back on claim. So it creates a situation where there's no financial disincentive for standard not to deny claims and continue to do that, because realistically it could turn out that their worst day in court is just paying you the money they owe you. So I think all these things kind of build up to make it just a very difficult, you know, process in litigating it. You know, and in like the prior video, you know, discusses, that's why your appeal is so important, because that's going to set the groundwork for success, or, you know, a quote-unquote win, you know, in litigating against standard.
So, Alex, when we think about litigating against standard, it's all going to come down to how that administrative record looks. So, as Steve mentioned, we've done other videos where we talk about how important it is to have a strong appeal. But we also know if we didn't do the appeal for someone and they call us and they've been denied by standard, more often than not, standard probably did, at a minimum, a halfway decent job, as opposed to other companies that we'll look at and we'll go, they probably did next to nothing. They probably went to their same people. They probably ignored the information you sent them. They probably went back to the same doctors. They probably committed 2 or 3 ERISA violations. Standard's not that foolish. So when we first start from scratch and we get it, we already know, as you stated, Stephen, that the law is not on a claimant's side, that you're starting with an uphill battle. This is not the way in which everyone thinks about, I'm getting my day in court. Yes, you're getting your day in court, but you're not being able to be heard. You're not being able to cross-examine or ask questions of anyone at standard. We're not able to talk to any of their doctors. The judge is never going to get to see you, and clearly if the judge could see you and hear from you, the judge would have that component of emotion, connection with you, and get to know you, but that's not going to happen. So I want people to understand, so how is this going to happen, Alex? What is the technical nature of what's going to go down in this process as we go through suing the standard for their long-term disability denial?
Well, once a complaint is filed, the insurance company has a certain amount of days, 30 days, to file a response. It's called an answer. Answer is pretty, you know, formulaic, whatever you want to say. They're just going to deny all of our allegations in the complaint. Once that's filed, the judge will issue a scheduling order, and it'll give us all the deadlines in the case. So the court will require mediation, and obviously a deadline to file your motions for summary judgment, which, however, these cases are typically judged by ultimately determined by the judge, is by each side's motions for summary judgment and the responses. But during that process, before you even get to mediation or filing all your motions, a lot of the times we'll be talking to the other side. We'll be talking to the insurance company because there's informal negotiations. Then there's a mediation. Like I said, the courts require it. The parties have to come together to see if they can come to a settlement. The courts love settlements. If there's no settlements, our entire judicial system would fail because it would just collapse. It'd be too many cases for the courts to decide and not enough judges out there. So the courts love settlements. They want to put the parties together to settle. When people come to me and I didn't do their appeal and I look at the denial letter, I might think to myself, the odds of winning this one are low. But you know what? There's still a chance of winning. And if there's a chance of winning, there's a chance of getting a decent amount of money from the insurance company out of a settlement. I told all my clients, you're the pilot, I'm the navigator. I look at the case and I say, you might have 10% of chance of winning here. ERISA is really against you. You could have done a better job in the appeal. I think we should make a right turn here and talk settlement and try to get the best number out of them. And my client says, no, I want to keep on flying straight through the storm. It's ultimately up to them, right? But we're going to give a full, honest evaluation of our client's claim to them. You know, we never push anyone to settlement. We're going to tell them what I would do, what I tell my mom or dad would do, give them the best advice possible, but ultimately it's the client's decision. But there's a lot that goes on to all these cases even before we file the motion for summary judgment. There's a lot of strategy in negotiating with Standard. Again, they do a thorough job of their claims reviews and denials and whatnot. But if my client really is disabled, that means that there is an opening there. There's something here that we can utilize to win this case. If we did the appeal, it's probably better odds than if we didn't do the appeal. But I'm happy to talk to anybody and review any case and probably file most lawsuits if I think there's any chance of prevailing.
I know a lot of people will Google ERISA law and find a lot of bad stuff, you know, more negative than positive. But there are some positives with this ERISA law. For example, many states don't allow for prevailing party attorney's fees. Whereas in ERISA, if you prevail on the merits, certainly at the discretionary of the judge, there could be an attorney fee award. That's very beneficial. There's a lot of cases we get that are ERISA exempt in certain states where there's no attorney fee provision no matter what. The insurance company, first of all, that stinks for the client. And the insurance company doesn't care because they're like, we're not going to get stuck with potentially a couple $100,000 attorney fee award. So you lose leverage. So that is one nice thing that comes in through ERISA. The other thing about these ERISA lawsuits is they're not expensive to litigate. Our private ERISA exempt cases where we do take depositions and we do go to trials, tens of thousands of dollars, if not upwards of over $100,000. I mean, depositions alone cost $1,000 to $1,500. Doctors want opinions. They charge you $600, $700, $800 an hour. So these cases are not going to be expensive, which allows you to move forward and do everything that needs to be done. Also, very strict timelines because we're in federal court. Very beneficial for a client that a judge is almost always going to make us get to a mediation within 6 to 9 months on average because these judges are overwhelmed. Not with these cases, but they want to push them. That's great. You end up in a state court, 2 years, you're lucky till you find a trial date. So it's going to move. The other thing about ERISA that I think is a positive for someone, the case law is the wild, wild west. It's all over the freaking place. For every opinion that you find supports our position, you'll find an opinion that goes the other way. Why would someone say, Greg, why is that good? It's good because if you have a case that's maybe not that strong, but yet you find another case out there that supports your position, you have life now. We just breathed the life into your case. Whereas the case law generally is saying, look, you've got to prove that the company acted unreasonably. But if you can find one case out there, which we can almost always find, there's a chance that the judge or the law clerk who's reviewing this particular file is going to say, you know what? I think you didn't act unreasonably. I like this case. I believe what they said here. I like your facts. And now the judge, if the judge likes the person or wants to fine for the person, has a reasonable basis to reverse the case. So there is a lot of opportunity with this ERISA law. And like you said, Alex, we're going to tell a person up front, we're going to say, look, you have an 80% chance, you have a 50% chance of winning. And also, not only that, here's the value of your case. Here's the range of the dollars we think we're going to get you. We're almost never wrong with that. And if you understand that and you know what you're up against, then it's going to be a good working relationship. But you're not going to call us. We're not just going to take your case and be like, oh yeah, we're absolutely going to win. And then down the road, get you 5 cents on the dollar. And you're like, what are you talking about? It's not what we do. We limit the cases that we take. We fight them till the end and we tell you the reasonable chance, but we got to have a relationship with the client as well to understand where's this going. And Standard can be reasonable. And they know from us, they already know that we've taken them to battle so many times. the clients are getting a lot of firepower by working with us and understanding that relationship, that we don't have to litigate with them for 6, 9 months, 12 months and be like, prove yourself to us. We've been there, done that. So it's a good summary that you guys have given of these lawsuits. We like people to know. It's great. A lot of people who call us have already watched this type of video, so they have a reference point to say, what should I expect? So the next step is we got to get that final denial letter, likely eventually get your claim file. We can immediately move on filing a lawsuit, and we'll have a conversation within a 30-minute period to say, kind of, this is where we're at, this is where we can go. And importantly for the clients, we don't charge any fees or costs unless we win. So there's no risk for the client. Alex, a lot of times you say, clients are like, oh, I don't want to be bogged down with litigation. They're strong-arming me to go back to work even though I can't really do it. I can breathe, I can survive. I'm going to go there. I'm not going to do a good job. But there's no involvement for the client. Meaning the client doesn't have to do anything. So that's a little bit of that's a positive also, because you know how demanding it can be for these clients. We're going to do every single thing. The only thing they have to do is be available for a mediation, be available for phone calls, and just continue to treat with their doctors. So if you're someone out there who's been denied by standard, you have a lawsuit to file, feel free to call Stephen, Alex, myself, no matter where you live in the country. We'll provide you with an immediate free consultation, and we look forward to the opportunity to speak with you.